My name is Steve Mason. I'm a candidate for the executive board of Cap City Lodge 9. I'm running for the position of recording secretary. I served our lodge for a number of years as a grievance rep, and during that time, one of the things I tried to focus on was educating, especially our newer members, on exactly what their contractual and legal rights are as both employees and as union members. And the topic I want to discuss today is union representation during interviews. And this is a topic where I feel that there's a lot of misinformation out there, and not many of our members understand just how far their rights go in this regard. So if you are represented by Cap City Lodge 9, if you look in your contract, there's going to be language in there that guarantees you access to representation during any official interview, interrogation, or questioning. So this covers internal affairs, this covers your chain of command, it even covers outside entities doing the questioning, as would be the case with like an EEO complaint. However, in addition to having access to a rep during those official investigations, you also have access to a representation anytime you're answering a question from a supervisor and you have a reasonable belief that the statement you're about to give could result in disciplinary action. So I'll say that again. Anytime you're answering a question from a supervisor, anytime, even if it's not during an official interview, and you have a reasonable belief that what you're about to say could get you into trouble, you have a right to a representative before you answer any other questions. But there are a couple limitations here. Number one, you have to make this request yourself. The employer is not under any obligation to tell you that you have a right to a representative. So you have to make a clear and concise request before you answer any other questions that you want to speak to a rep. Now, this right outside of what's in our contract comes from a 1975 Supreme Court case known as Weingarten. There was a woman, 1972, she was working at Weingarten supermarkets. She was working at the lunch counter, and she took some chicken home with her after her shift. And her supervisor accused her of essentially stealing the chicken, of paying for a small amount of chicken, even though she had taken a large portion of chicken. And so they called in a loss prevention agent who did an investigation, and repeatedly throughout this entire investigation, Ms. Collins requested a union representative, and repeatedly the company denied her access. They never gave her a chance to speak to anybody, to consult with a rep, nothing like that. They insisted that she answer questions without representation. So as the investigation progressed, what eventually was discovered was that Ms. Collins hadn't done anything wrong at all. She had actually paid the proper amount for the chicken. She had taken 4 pieces of chicken, which is what constituted a small amount, and the store was out of the small containers. So she placed the small amount of chicken in a large container so she had something to carry home in, and that's why she had paid for the small amount, because that's all she took. So Ms. Collins was fully exonerated during this investigation, and at the completion of it, her supervisor brought her in and ordered her not to discuss this with anybody else, not to discuss the investigation, the accusation, or anything. She wasn't allowed to talk about it. Well, fortunately for us, here in 2018, Ms. Collins didn't comply with that, and as soon as she left work that day, she contacted her union, told them that she was denied representation, and explained the entire situation, and they immediately filed an unfair labor practice. And then 3 years later, in 1975, we have the ruling from the Supreme Court that guarantees us right to representation, just like we previously discussed. So again, you have a right to representation during any official interviews, interrogations, or questioning, but you also have a right during any time you're answering questions from a supervisor and you have a reasonable belief that disciplinary action could result from that conversation. All right. Once you make that request, the supervisor can either end the interview altogether, or they can delay it until a later time when a representative is available and gets a chance to meet with you. So if you have any other questions about Weingarten, about any other union-related issues, please comment down below. This is actually part 1 of a 2-part series I'm going to make. The next video is going to cover rights under Weingarten for the union representative themselves, because it also has some language in there discussing what a rep can and cannot do during an interview. So again, any questions, please contact me. Ballots go out on the 19th. I would appreciate your support for recording secretary. Thanks for watching.